Your Honors.
Okay.
You get to see the mess in my office then if I...
It's looking like the fog I drove here on.
Believe me, Ms. Booker, you don't want me to turn this virtual background off.
Try to ignore that. I apologize.
Okay.
We remodeled recently and I haven't finished. So.
Oh, sure. Yeah, I get it. That's what you tell everyone.
Yeah.
Okay, you're up.
May it please the court, Erin Berger on behalf of the appellants in this case, and I'd like to reserve 5 minutes for rebuttal, Your Honors.
Sure.
Your Honors, this matter stems from a property insurance claim brought by the appellants related to 2 losses in their home in July of 2016. At the start of the trial in this matter, the insurance company moved to strike the water mitigation documents and the expert report that the appellants had intended to rely on during the trial. At the motion to strike proceedings, the judge, in our opinion, misapplied the business records exception, erred in excluding these documents from all insurance restoration services, which I'll probably abbreviate to errors, Your Honors, and in excluding the expert witness testimony. Each of these errors, we believe, resulted in Ms. Polenko and her husband not being able to fully present their case, which resulted in the directed verdict for the insurance company. And for that reason, we're asking that the decisions of the trial court be reversed and the matter be remanded for further proceedings or a new trial.
Ms. Berger, when I read these briefs, I was focused on your very eloquent arguments about the things you've just raised, but I couldn't get past the fact that it was undisputed that under the policy, prompt notice had to be given of the loss. The property needed to be protected from further damage because of the loss, and that a record of the repairs were also to be kept, and the used parts should not be discarded. And it was undisputed that none of that happened. As a matter of fact, your own client testified to those things. So that being the case, why does the rest of this matter?
Well, Your Honor, I would say that those issues do involve questions of fact that should have been left for the jury to decide, and I'll explain why.
Well,
each of them.
Except for everybody agreed, even your client testified to that. They were undisputed. There was no evidence to the contrary that this leak went on. There was water pooling on a kitchen floor, pooling on a bathroom floor. She waited a long time, to do this. And in that long period of time, not only was not notice given, but there were no remedial efforts that were made. And then there were repairs that were made, and none of the things that were repaired were kept, and there were no receipts of this. And the policy clearly says you're not going to get coverage if you don't do these things. So she voided her own coverage, and I didn't see any dispute of that. None. So help me with that.
I will, Your Honor. And first, I'd like to address the notice issue. My client didn't concede, or the appellants didn't concede, that they gave late notice. I think that's a question of fact here. And it's important because there were 2 losses and the insurance company did not dispute that the first loss was reported or reportedly occurred in early July, the second one in late July. There's also no dispute that remedial efforts were made within a couple of weeks of at least the second one. And although it wasn't reported again for a couple of weeks, those remedial efforts there, at least cut off the argument with regard to the repeated seepage and leakage claim by the insurance company with regard to the second claim. But I think that those issues are also still up for debate in terms of facts and whether or not that would constitute a breach, because there is no term under the policy that says exactly when the appellants have to give notice. There's nothing that says that they have to give notice within 2 weeks or that they have to give notice before remedial efforts are taken. Part of their obligations under the policy is that they mitigate further damage, and she did try to do that once she realized that she did have a bigger problem than she maybe originally appreciated. And again, the first leak was one that, she thought maybe she testified maybe somebody had just spilled some water the first time in her bathroom or her closet. And she tried to dry it up. But she didn't know where the leak was coming from. And it turns out, based on the heirs documents, that it was a leak that was within the wall. So it wasn't something that she maybe would have known of. And also, we're talking about an 88-year-old woman, and taking into account that it seemed that she did have some issues with her memory, and she did testify that she'd never dealt with anything like this before. I think that those are factual issues that should have been taken into account. With regard to the showing of the damaged property, again, there's nothing in the policy that defines damaged property. There's nothing that's in the policy that says that she has to maintain broken plumbing parts. There's nothing in the policy that says that she can't do these remedial measures before contacting the insurance company. She did these things. She does, again, nothing that she had experience with before, and heirs came in, did the repairs, and she thought she was good. And she provided the insurance company with the documentation from heirs, and that's the documentation that she had. She can't produce things that she doesn't have. She didn't make any repairs other than the heirs' remedial efforts before the claim was denied. And the testimony that was established, at trial and through her deposition was that she didn't replace the floor until sometime after the claim was denied, and even possibly after the complaints were filed. So there's questions of fact there, whether or not these were actual breaches of the policy, and they should have been taken to the jury. These issues were also not the original basis for the motion for a directed verdict, and the basis under which the trial court reviewed whether or not there was enough to submit to the jury was based on the jury instructions, not based on what would be required to survive a motion for a directed verdict, which is whether or not she met her prima facie case, in that there was a breach of contract, she suffered damages, and could prove that she had damages. And going back to the exclusion of the evidence, had her expert been able to testify, as we think that he should have been able to, there would have been evidence as to causation. There would have been evidence of her damages, because in his deposition, he testified that he independently came up with estimates.
Which actually, you're talking about Rivero or Parsons? When you're talking
Rivero, Your Honor.
Okay, Rivero didn't even visit the project until 3 years after the fact, right?
Correct, but he did say that he's been doing this for a very long time. He didn't notice any evidence of any sort of long-term damage at the property, no evidence of any mold.
But it had all been fixed by that time, right?
She testified that the only thing that she had done, Your Honor, was replace the carpet. Nothing had been done by the time he inspected the property. That still had the
there
boreholes.
were no repairs made to that property at all as a result of these 2 leaks?
Correct, Your Honor. She said that the only thing that she did, because she had to, but because the carpet was ruined, was replace the carpet and replaced it with her some flooring, and that was the only thing that she had done. And again, that was even after the claim was denied and after she filed these complaints. There's that she didn't retain I didn't review the discovery to see if that was something that was requested and should have been produced. But again, these were not issues that were in the insurance company's frame of reference when they denied the claim. It was denied based on coverage, at least the bathroom claim. And the errors in the trial court, excluding the documentation that she did have and did provide in a timely manner to the insurance company, and preventing her expert from testifying, prevented her from being able to—
About the Parsons report now?
I'm sorry, Your Honor.
You're talking about the Parsons report now? Is that what you're talking about?
No, Mr. Parsons didn't prepare a report. He's the representative from heirs. Rivero was the expert who prepared his own independent report. And again, this goes to the issues that we raised on appeal, and that the trial court erred in excluding these records because Mr. Parsons, as the corporate representative or records custodian for heirs, did testify to all of the elements of the business records exception.
No, except that he said he had no involvement in the project, never visited the property, never spoke to your clients, and doesn't know who any of the technicians were.
He's not required to have any personal knowledge. Not under the business records exception. He's a records custodian. He was testifying as to the business records of heirs, that the records were made at or near the time of the event. He testified that he has knowledge of how he's the operations manager of heirs. He was trained by the owners of the company. He knows how they prepare and keep these records. He said he was actively involved in keeping these type of records or in this type of activity. He testified that their policy is that 2 to 3 technicians go out to each job, one of them being a certified technician. The certified technician is the one that would make these handwritten notations with regard to the water mitigation efforts. He testified that this was something that was done with every job.
Ms. Berger, and did he testified something that I think actively participated in similar type of work. So he was familiar with the type of work that was done by those folks, right?
His testimony in the record didn't expound on that, Your Honor, but he did testify that he was actively involved. He did actively participate in this type of activity.
And similar type. So here, my question is the expert here, Rivero, without these records, he couldn't give an opinion. Is that right?
That's not correct, Your Honor. He actually testified during his deposition that even without the heirs records, he would have been able to conclude, and he felt comfortable concluding that this was a plumbing loss. He said that.
And how could explain for me how in your opinion, he was able to do that?
He based it on his experience. He even testified that before he even reviewed these things, the contender claims estimates and the heirs documents, he goes to the property first, talks to the property owner, and does his own independent inspection, and based on his 30 plus years of experience, made his conclusions here. Then he goes back and he reviews all these other documents just to kind of make sure that, you know, everything is reconciled together, and he feels more comfortable making the decisions or the conclusions that he makes based on the information available to him. He testified that in these types of cases, there's about 3 ways that these things normally happen, like a weather event, something in the roof or the walls or windows, and he saw no evidence of any of those types of leaks, but he did see evidence because based on where the water damage that he was able to observe himself, he did say that this would be a plumbing related loss. He noted that there was water damage on lower walls, lower cabinets. Ms. Polanco had retained a piece of the drywall that was wet. He based his opinion on the damage that he saw to that, having seen no mold, no corrosion, no rust or anything in the areas that she said the leaks came from. He was able to conclude based on his experience that these things came from a plumbing related loss. He specifically testified that even without the heirs documents, and this is on page 674 of the record, Your Honors, even without the heirs records, he felt confident that this was a plumbing related loss.
Well, Judge Holder found basically in ruling with regard to this that he saw no evidence regarding whether the documents and information were made from information transmitted by a person with knowledge.
Correct, Your Honor. He did make that conclusion, but I would say under the law, there's no requirement that Mr. Parsons testify as to the names of the people that attended to this matter, or that he testifies specifically as to their training in order to have these documents admitted into evidence under the business records exception. This court's decision in Jackson versus Household Finance Corporation that was taken up to the Supreme Court and affirmed involves sorry, Your Honors, I'm trying to find the exact language here. The court concluded that there's nothing more that's required of a witness under the business records exception, anything other than, you know, he or she testify as to those 4 elements. He doesn't have to go into specific detail about his knowledge and or the basis of his knowledge. Here, Mr. Parsons unquestionably demonstrated his knowledge of the heirs policies, practices, record keeping.
It's regular business practice.
I'm sorry, Your Honor.
It's regular business practice that these documents are compiled with information given by the people who went to the scene.
Exactly, Your Honor.
And then maintained.
Correct, Your Honor.
So what's our standard of review on this issue?
Because it involves the application of the law and the business records exception statute, it's de novo, Your Honor.
Well, it's a ruling on the evidence, isn't it?
It is, but it involves the interpretation of the statute here and the application of the statute.
Well, doesn't every ruling on the evidence involve that? Every ruling on evidence involves interpretation of the evidence code, right? Yet the law is overwhelmingly clear that that's an abuse of discretion as our standard of review in a ruling on the evidence.
I would submit that in this case, because the argument is that he misapplied the business records exception, Your Honor, you have
well, again, isn't that the argument on every evidentiary ruling, that the judge misapplied that specific evidentiary rule Yet all the cases say that a ruling on the evidence comes to the appellate court to be considered under the abuse of discretion standard.
Yes, but as I cited in my brief, Your Honor, a trial court's discretion to admit or exclude evidence is limited by the evidence code and applicable case law, and a de novo standard review applies if the issue presented on appeal is whether the trial court erred in applying a provision of the Florida Evidence Code, and that's I cited a first DCA case there. So
the question of whether evidence is relevant, given all the other evidence and circumstances in the case, is really a matter of discretion with the judge who's sitting there. But whether relevant evidence should be excluded under a provision of the evidence code becomes a question reviewed de novo. That's your position.
I'm not sure in that context, Your Honor, but I do know in this context I've handled a few of these business records exceptions cases, and I've run into the same standard in many of those cases, including some of the ones that I cited for Your Honors, the Jackson case, and a lot of these mortgage foreclosure cases that I'm sure that Your Honors are familiar with, where there's no requirement that the records custodian that presents this information is able to identify each and every person that makes an entry onto these records, is able to talk about, you know, that person's experience or knowledge or certifications or training. The only thing that's relevant to the court's inquiry here is whether or not he was able to satisfy the 4 elements. And I will say that the insurance company makes an argument in their initial brief that I didn't find any reference to in the record, particularly that this was double hearsay or hearsay within hearsay. But to that statement, I would say that it still meets the threshold here, because the information that is maintained and put into these records is also information that's maintained as they're within the course of their regular business and in the normal business practices to record this information. They do it with
Ms. Berger, I've let you and Judge Morris and me argue into your rebuttal time, so you can keep going or save your time for the rest.
I'll save my last few minutes, Your Honor. Thank you.
Okay. Mr. Tinker.
May it please the court. Good morning, Mark Tinker on behalf of Security First Insurance Company. I'd like to start where you did, Judge Morris, and say that essentially, you know, all of the issues that have been raised on appeal with regard to the evidence, the photographs, the expert testimony of Mr. Rivero, none of that has anything to do with the directed verdict that was granted. None of it would have affected the outcome one way or another. What the judge did is he ruled, well, she hasn't proven, and the way he phrased it was the second and third elements of the jury instructions, where he looked at what do you prove for breach of contract. And number 2 is, did she do everything that the contract required of her? That's one of the elements she has to prove in order to prove a breach of contract. And Judge Morris, you know, one of the things that you highlighted on right from the beginning was the prompt notice requirement. The policy says that if there is a loss, an insured has to give prompt notice. The law is very clear that the reason for that, and it's common sense, is that insurance companies have the ability to investigate, to, you know, avoid fraud, to try to figure out where, you know, did this loss happen as was claimed? What is the extent of damages? Was there pre-existing damage? All of those things the insurance company needs to be able to look at. This court in Lobello versus State Farm said, you know, when prompt notice is put in a policy and undefined, what that means is as soon as practicable. You have to look at it under the circumstances, but the court in Lobello also said that that is something that if the facts are undisputed, the court can decide that as a matter of law. Here, the facts are undisputed because Ms. Polanco testified to them. And the issue is not so much a matter of duration of time, even though the duration was lengthy. It was over a month that before she reported anything.
I mean, according to what I read, the bathroom loss based on your insurance forms was on July the 2nd of 16. The kitchen loss was July 27th of 16. This is again according to your client's form. So I don't know how accurate that is or not. And that the claims were not reported until August 25th of 16. Okay. So my question to you is, were those dates at all disputed?
The dates, I don't think anybody knows the dates. So I don't know if you want to call it disputed, but they were, Ms. Polanco.
I mean, was there a case made that, no, it didn't happen then, we knew it, we found it later, or we reported it sooner? Was there any dispute about that?
Not in that, not as the way you phrased it. It wasn't a dispute. It wasn't challenged, but Ms. Polanco said she wasn't sure. She looked at the dates and she said, I didn't actually give those dates. Contender put them on the forums. She thinks All Insurance or heirs that they were referred to actually gave the dates. So nobody really knows who put the dates there. And she said, I don't think those are accurate, but I'm not exactly sure. So there was confusion as to the dates, I think is probably the better way to put it. But what we do know is no matter what version of the dates you went with, it was at least a month before the claim was reported. And the more important part is what happened in that month, where Ms. Polanco, called the consulting company. They engaged a remediation company. They performed work. They tore out all of the damaged materials. They got rid of the damaged materials, discarded them, did some repairs. She hired a law firm.
So it was more than just the carpet was replaced.
Correct. It was everything.
I was a little stumped by that. I remembered reading more than a carpet being replaced, but I wasn't sure.
Correct. And you'll see at record page 1249, that is where Security First Inspector went out to the property. And that was on September 19th when they were finally allowed into the property. They weren't actually allowed access at first. Ms. Polanco's consulting company, Contender, wouldn't let them in. But finally did let them in, and the report says, looked around and saw that there was evidence that something had happened, but could not tell the cause and could not tell when because none of the stuff was there. All of the damage, the allegedly failed pipe was gone, the drywall was gone. There was nothing to look at to be able to tell the extent of damage that might have happened and when it happened. And I think that I'm going to kind of morph a little bit into the evidence as far as Mr. Rivero. That's the key. One of the things as to his testimony that was excluded is even he said, I don't know when it happened. In his opinion, with these photographs, without these photographs, he said, I can tell you that there was a plumbing leak, which I'm not sure that was ever disputed. But he can say, I can tell you there was a plumbing leak and it caused some damage. But he was asked, can you date that? And he said, no, I can't.
But Mr. Tinker, why can't he rely on the property owner's information?
Well, I'm not sure that that's an expert opinion. If he's just parroting to us what Ms. Polanco told him as far as the date.
You're saying he can't rely on the information from the property owner?
He can do an interview of her and he can rely on her, but to say that that's a basis for him to come in as an expert opinion and tell us that this is the date that these pipes failed, he's really just parroting what she said, and she's already told us she doesn't know. She testified to that at trial. She said, I'm not exactly sure when this happened. She had an entire range of dates saying that she noticed water at certain times in the kitchen and the bathroom, and she changed her testimony back and forth. Sometimes the kitchen happened first before the bathroom, and the other times it was the bathroom before the kitchen. So no, he wouldn't be relying on anything as far as
Okay, so if let's say the heirs records were not excluded, in your position, could he have relied upon the heirs records if they met? Let's assume they met the business record exception. Could
I think that's an important thing is I believe the judge did find that they met the business record exception.
I understand, but take my scenario and let's assume that the records met the business record exception. Could Rivero have relied upon those records?
No, and that's the second part of it because they were actually double hearsay. And
okay,
that's what no,
but you're missing my point though. Let's say all the records met the proper foundation. They met all the criteria under business records exception. Okay, forget the double hearsay. I completely understand your argument. Could Rivero have relied upon those records?
If the judge found that those are the types that are reasonably relied upon by experts in his field, then
if they met all of the criteria that they were supposed to, yes,
he could.
Even forgetting that they were under Judge Smith's hypo accepted from the hearsay rule, even if they were double hearsay, if they were the kinds of things that an expert generally relies on, he could rely on them, correct?
He could, and
certainly your side is willing, certainly your side is able to attack the accuracy of what he's relying on, but that doesn't mean he doesn't get to testify on the basis of them.
I agree with that, but we put a lot of ifs in front of that question in order to get.
There are always a lot of ifs, but The question
and I
boils
think,
down to,
Well-
were these appropriate, or were these business records that,
well,
and even if they were excluded, couldn't he rely on them?
he could, if they were, again, if we were to get all the way there and say these are the types, they were authenticated and everything was fine in them, and these are the types of records that people in his field rely upon, and he did, and he offered his opinion, we'll go back to where I started with Judge Morris, and it would be irrelevant to the decision that brought us here today. You know, he
But
would,
Mr. Tinker, I'm having a hard time understanding why they didn't meet the business record exception.
They did.
Because what your
You don't dispute, Mr. Tinker, that these were within the business records exception.
I do not. I do not. And I believe that's what the judge found. He said, and I actually had the quote right in front of me. He said, clearly, Mr. Parsons has testified that the documents were kept in the ordinary course of a regularly conducted business activity. He said he found that they met the business exception. But then he went on to say, but they were not, it's not shown that they were transmitted by a person with knowledge. And that's the key, is not only were these pictures that were kept in the course of business that makes them business records, but they're pictures of someone holding a thermal imaging camera and moisture meters taking readings. And Mr. Rivero's not looking at those because they're pretty pictures. He wants to see what that number is and know where the moisture is and how much it relates, to the thermal imaging shows, is there more moisture on the baseboard versus higher up on the wall? They'll tell you if the water's rising up the drywall. He's reading those numbers and looking at those thermal images. That's what he's looking at the pictures for. So who did that? Nobody even knows who that person is, whether the instruments
Mr. Tinker, so would it's Mr. Parsons, excuse me. So if Mr. Parsons then, would he personally have to have taken the readings for those records to been able for Mr. Rivero to rely upon those records?
No, but he would have to be able to authenticate them in order to provide, this is he didn't even know if it was their employee who did it. He didn't know who took them. And so, so not only would he have to be able to say, okay, this is our person who did it. These are our cameras. We know that we calibrate them once per month or whatever it might be. He would have to lay the foundation to say these scientific readings that are depicted in these business records, this is why you can rely on them. You can't have an expert look at a picture and nobody knows who took it or what that camera is or whether it's accurate.
But doesn't that go to the weight of the expert testimony and reliance on them versus whether they are admissible as business records, because they are maintained in the course of the business, as this fellow testified to and as the judge found, and if he testifies that it's the business practice of the business to send people out there to take a look, and then they record what they have found, and that goes in the file, doesn't that satisfy the requirement for the admissibility of this stuff?
No, he can't testify that he's just collecting data from any source and nobody knows where it comes from or who took it and make that reliable. And that's where Judge Holder in his discretion can look at it and say, this is not reliable evidence. And that's where it fell outside of what Mr. Rivera was able to rely upon. And it's, section 90.704 of the evidence code says that he can rely on inadmissible evidence if it's the type reasonably relied on by people in his field. And Judge Holder said, this isn't reliable because nobody knows.
That's not a requirement. That's not a requirement for his ability to rely on it. That's why you then cross-examine and impeach and seek to undermine based on the alleged unreliability of the material. But if it's the kind of material that people in his field generally rely on, doesn't the evidence code say he's entitled to base his opinion on it?
But Judge Holder found in his discretion that it was not reliable evidence, so that
It doesn't
cannot
have
be
to
something
be.
that
That's what I'm
people rely
saying.
on.
He may have found that, but it doesn't have to be for the expert to rely on it if it's the kind of information that experts rely on, typically rely on to give their opinion in the field.
And then Judge Holder, as the evidentiary gatekeeper, looked at it and said, this is something that's completely unreliable. It cannot be used to form a basis for an opinion. And that's, I will go back to, I think that's the key to it, is number one is the discretion. Number two, he's looking at the reliability.
But we're talking about not his discretion whether to admit evidence generally. We're talking about his belief in what the legal requirements are for the expert to give an opinion, correct?
Correct. And he ruled that the expert cannot rely on evidence that he's already deemed unreliable to form the basis for an opinion. And then I'll go back to
Well,
at the
he
end of the
hasn't
day.
said that evidence was unreliable. He said he just didn't know who made it for purposes of the business records exception, correct?
Correct,
Certainly, Judge Holden could have no opinion on whether these readings were reliable or not, if
Well,
he didn't know where they came from.
No, he did actually on pages 1939 and 1940 of the transcript. He said that he's stricken them because they were not reliable, and that's why he did not allow Mr. Rivero to rely upon them. He said it, it's not about it being inadmissible hearsay. He said these are unreliable documents. This is unreliable evidence. And then I have to just go back to it because we've been discussing Mr. Rivero and his opinion and these records. And I just go back to the fact that where I started with Judge Morris's first question is that none of this matters because.
Yeah, I mean, I've been listening to all this thinking the same thing. So let me ask you a question.
That's what he often thinks about stuff that I talk about.
Yeah. Let me ask you a question separate and apart from all this. There was, there's a case been made that she didn't timely report the problem. The policy also, though, says it doesn't cover water losses involving constant seepage for 14 days. Relate those two things. Okay, so there's a separate provision that says we're not covering for something that you've ignored for 14 days has created seepage. And in addition to that, there's a duty to promptly report a loss. So, I mean, those two are separate things, are they not?
They are separate. One is the duty to report is a condition. It's basically a condition precedent to coverage, where if you have a loss, you have certain conditions you have to comply with in order to obtain coverage. The 14-day, the long-term leak is actually a policy exclusion from coverage. Where
is there any dispute about that in this case? I mean, was there any dispute that this was not a seeping leak that lasted at least 14 days?
No, Your Honor, that was her own testimony. She testified that it was constant, that she kept cleaning it up every day and it kept coming back. And whichever time frame you went with, I believe this is we went 47 days before she called Contender and 54 days before she called Security First was the shortest time frame I could come up with given the various dates. So we have definitely more than the 14 days, but she said this was constant in both areas, in the kitchen and the bathroom. She kept cleaning it up every day. It kept coming back. So that brings it within the policy exclusion, even though it is an exclusion from coverage. So that would, make it Security First burden. At this point, the only evidence is Ms. Polanco's own testimony, and it's undisputed. So that gives rise to the exclusion. The same, I think that there's the long-term leak exclusion, there's the lack of notice, and then there's also a condition precedent in the duty to keep the property, keep damaged property, keep receipts, all of those things. And she, of course, admits that she did none of that. She threw out the damaged property so nobody can tell exactly how this part failed or which part failed. We just know it was a pipe back there somewhere. We don't know how much of the drywall or the baseboards were damaged, how many, maybe it was damaged before, maybe it was pre-existing, maybe it was new, that she decided to just remodel the whole bathroom just because she had a small leak. Nobody knows. Because we weren't allowed to inspect it. She testified as to some of her own outlays, saying I had to do some work in there. In her deposition, she said I spent $5,000 at trial. She said it was $4,000, but I don't have any receipts for any of it. So how do we even know how much she spent when she can't even tell us and she doesn't have any paperwork? So all of those things, they were all failures of the conditions preceding to coverage. And then with the long-term leak exclusion, the 14 days, also a policy exclusion from coverage. All of those things are undisputed on this record. None of them have anything to do with these photographs that were excluded or with Mr. Rivero's opinion that was excluded. He didn't comment on any of those things. He couldn't date the loss. He admits as much in his deposition, said, I don't know when it happened. Even with all the evidence that he looked at with those photos, he couldn't date it. So none of those things would change. So unless you have any other questions, I'd simply ask that you affirm.
Thank you, Mr. Tinker. Ms. Berger?
Thank you, Your Honors. While I agree that there's certain facts that are undisputed here in terms of dates and things, the application of a lot of those facts is what is disputed. There's issues here with regard to whether the insurance company was prejudiced. And they make the argument that they are presumptively prejudiced because of what they have concluded is the time frame between the alleged date of loss versus the time it was reported. I think what's important here is, first, with regard to the bathroom leak, the policy exclusion that is covered, which is an affirmative defense that they have to prove, accepts anything, leaks that are hidden within the walls. And I've already made my argument with regard to that and why she may not have known to report that sooner, but this one was within the walls, and that is undisputed as well. With regard to the second claim, you can't take the date of the loss to the date it was reported, because in between there, it ended at least 14 days when she contacted heirs, and the first date that it shows that they were there is as early as August 10th. So we're talking about 14 days or less in terms of that second leak. So there's disputed issues here of fact and how it would be applied with regard to the conditions precedent and whether or not there was any prejudice to the insurance company. With regard to and the breach in terms of the timing and whether or not the timing of the reported loss versus the date of the loss is a question of fact for the jury to decide. And only then, when a breach is decided or when a breach is established, do they get that presumption of prejudice. With regard to the other conditions precedent, they don't get that presumption of prejudice. They have to demonstrate their prejudice that results from lack of compliance with the condition precedent. And they didn't even do that here because we don't even get to their case. With regard to their pairs, I didn't mean to misrepresent anything to the court. I just meant, other than the heirs remediation that she had already demonstrated to the insurance company, the only thing that she ever did otherwise was replace the carpet. With regard to the business records exception, I'm confused by Mr. Tinker's argument that the court found that they did establish, or the court said that he met the business records exception, but then argued that he didn't meet the second prong, which is exactly what the court found. He didn't meet the second prong in terms of whether or not the information was transmitted by a person with knowledge. And again, I would argue that all the information that Mr. Tinker argues that heirs should have been able to present, or in terms of scientific knowledge and training and the technical readings of that equipment, it's not required for the admissibility here. The reliability and trustworthiness issue goes to perhaps the circumstances under which these documents were created. In cases where this has been applied and documents have been excluded for lack of trustworthiness, for example, one thing, or documents that are excluded are ones that are prepared in anticipation of litigation. And that's a situation where documents do not have that, indicia of reliability that generally business records do have. And Mr. Parsons did testify that they have to keep accurate records, that their practice and policy and procedures are that the people that they send out, and I don't know where in the record it said that he wasn't even sure if they were his employees, but their policy was to send two or three technicians from heirs to complete this work, to prepare these documents for each and every job that they handle. And there's a difference between reliability under the business records exception versus whether or not an expert can reasonably rely on information from somebody else. That's not an issue of reliability. It's what an expert normally would rely upon in order to make their to reach their conclusions. And here, Mr. Rivero, he could rely upon the heirs documents, but even if he couldn't, even if the judge was right, he unequivocally testified that he did not rely on these documents in reaching his conclusions. In his deposition, he didn't even mention the heirs, the moisture levels and the heirs pictures. He in fact said he reached his conclusions and then reviewed the documents again just to reconcile the information and make sure that he was confident in his conclusions. And there was evidence in his deposition and based on his report that he could make a determination that this was not a long-term seepage and leakage because he did not see those indications of mold, rust, corrosion. The damage that he saw to the walls did not indicate a long-term event, but something that was more short-term. And he said that she seemed to nip in the bud or something along those lines in his deposition testimony. Again, all the issues and some of the reasons that the court specifically cited in granting the directed verdict could have been avoided and would have been avoided had the judge correctly applied the business records exception in permitting the heirs documents based on Mr. Parsons' testimony, unequivocal testimony that he could establish the admissibility of these documents. The court erred in excluding Mr. Rivero's testimony, claiming that he couldn't rely upon these documents, which we argue that he could based on the law here in Florida. And because even if he couldn't, He didn't rely on those documents, and he should have been able to testify as to his own independent inspection conclusions. With his testimony, Ms. Polenka would have been able to establish causation, would have been able to establish damages, and would have avoided directed verdict in this case. And for those reasons, Your Honor, we request that you reverse and remand for further proceedings.
Thank you both very much. In order to leave this virtual space, you need to click the leave button in the lower right hand